This is the Hidden Killers Podcast with Tony Brueski.
Featuring defense attorney, Hidden Killers daily contributor, and host of the Defense Diaries podcast, Bob Motta.
Well, every week we get to sit down with Bob Motta and find out what crazy new things have happened in the world of the Delphi murder case. A case where everybody just wants justice for two little girls. Unfortunately, as we've seen in the last year, the case has almost turned into anything but, more so a referendum on the legal and judicial system and police system in Delphi, Indiana. Here to discuss the latest, as always, Bob Motta. Bob, we got two original actions this last week that have been addressed by the Supreme Court of Indiana. That first one talking about Judge Gull and almost kind of being moot, if you will. They kind of think Judge Gull getting back into the docket, correcting things, fixed all of that problem. Why don't you enlighten us a little bit more on that motion, what it was about, and why it's pretty much sitting there and they're saying, okay, we're good on that one before we get to number two.
Yeah. Hey, Tony, how are you, man? Good to see you. So that first original action was basically exactly what you said. If you followed the Delphi case at all, really since the moment that Richard Allen was arrested, the docket was handled in a very peculiar way, in the sense that the judge, who she's a subsequent judge, like the original judge, this Judge Diener, had recused himself from the case right after the arrest. And he was the judge. And remember, Carroll County is very small, very, very small county, not many judges at all over there. So when Diener recused himself, basically citing his concern for the bloodlust from the public, which at this point seems prophetic or like he knew something, in terms of how this case was going to go down. So they ended up assigning a special judge, which was Judge Gull, from a different county. She's up in Allen County, which is up in northern Indiana, much, much bigger county, much, much bigger court system up there. They have a lot of judges up there. It's probably one of the top three cities in terms of population in Indiana. You got Indianapolis and Fort Wayne, which is where it's housed right in that county, is a pretty big town up there. So she ends up coming down, taking over the case. And right away, like right after the arrest of Allen, the prosecutor's office says, hey, you know what? We want to file this PCA under seal. And I think that we've discussed this a bit. I was scratching my head as to why. Publics are supposed to be trials are supposed to be public. We want that for transparency, for accountability, for various reasons, none of which more important than the fact that it's constitutionally mandated that trials are public.
Yeah.
So,
if nothing for that reason.
That's a big one, right? So, right away, I'm kind of like, man, what's going on with this thing? I had done a couple of podcast episodes about it. I'm like, this is strange. So I think she ended up releasing the PCA, unsealing it in December, if I'm correct. And when I saw it, I'm like, wow, yeah, why did she seal this? It's like your typical PCA. Yes, obviously it's dealing with, a very traumatic event where two beautiful little girls lost their lives. But the fact of the matter is every murder is horrific.
Yeah.
All of them, whether it be children, we feel it more because obviously our thoughts automatically go to our kids. So we feel that empathy in a different way. But every single loss of life like that is tragic, so I was just I was wondering what made her do that. And a couple days later, the defense issued a press release where basically they countered the PCA, which is not typical. Typically, PCA comes out, that thing's floating out there, and that is what ruminates in everybody's head while trials pending. That kind of like the state's theory of the case is typically what everyone is basing their initial opinion of innocence or guilt on, and that's why almost everybody in every criminal case, when there's a PCA leans heavy guilty because that's the only story you're hearing. Like if I could just tell one side of a story all the time, people would probably believe me, no matter if it was true or not, because they're not hearing an opposing side of it. So it was unusual that they did that. I, as a defense attorney, loved it. I was like, wow, that really evens the playing field. That gets the defense's narrative out, the defendant's narrative out. And I like that. We want an even playing field going into a trial. So I think that kind of irritated the judge, which was evidenced by the fact that she very quickly ordered a gag on the case, meaning that none of the lawyers, nobody involved with the case was allowed to talk to the media about the case other than, procedurally what may have happened in the court that day. Like, can't talk about any underlying facts, can't talk about innocence or guilt, any of that stuff. So, it continues to progress, and like I'm watching the docket pretty thoroughly. And, I'm like, there's just not much going on with this case early on, and there wasn't. There was a couple things filed by the defense. There was this one thing called a let for bail, where they were trying to come in and say, look, we don't think, based on what was in that probable cause affidavit, that there's enough there to keep him held in custody without bail, or with such a high bail amount that, he could never possibly come up with that money. It's the equivalent of not having a bail. So I was excited about that hearing, because what that would have meant is that would have forced the state to provide more evidence. It's like I spent many, many months battling with people on Twitter. I don't know if they practice law or not. I tend to think that they did not, that were of the mindset that law enforcement holds back huge smoking gun pieces of evidence from PCAs. And that's just, I'm here to tell you, that's not the case. I mean, they're going to put their best foot forward, typically in terms of a PCA, because they understand exactly what I was just talking about. That is what is going to be out in the public. They want, if you have the advantage of getting your story out first and having it sit out there, you're going to want it to be as powerful as possible.
Sure.
And there's no logical reason why they would hold anything back, because the defense gets everything in discovery anyway. So, whatever they have at the time, pre the post-arrest investigation, they're going to put in the PCA typically. And, I'm just sitting there. I'm like, I couldn't wait for that hearing. And I get there, and it turned out that it didn't happen. And there was no notice of it. So I started to see this trend, because I'm always in person in the courthouse over there, that, the docket would say one thing, and then I'd get there and it was something different that was being handled. And she had basically sealed off the file, where we can't even see the court filings. It's one thing, typically we don't have access to discovery, evidence and things of that nature pretrial, but it's very unusual for us not to be able to look and see what the pleadings are, motions that are filed, all that kind of stuff. That is always supposed to be public domain, and we're supposed to be able to, again, for transparency and accountability, we should be able to see that, especially in this day and age when you have the internet just frothing at the mouth over true crime. We all are very interested, and we all want to know what's going on. And, in considering that that's kind of the climate that we live in now, I found that it was very unusual, and I didn't know why she was at that point kind of keeping the case in the shadows. And so it continues on up until June. And I think at the hearing in June, when defense counsel was trying to get Richard Allen moved the first time, that she announced publicly that in court that she was going to be releasing 118 documents. There was going to be a big document drop. And then it came to be known that she, instead of just putting them on the docket, she ended up creating this weird website, or the clerk's office, whoever created it. And, that they were going to dump them in there for the public to access them. And then when that happened, I found it very troublesome, very, very difficult for, nothing was organized. Couldn't tell what one document was. None of the documents were titled. They were all dated the exact same date, which was the day that they dropped them. So yeah. It's
I want to ask you about that specifically. Was that just gross negligence in that, or was there like a purpose to this? Like, let's make this as convoluted and difficult as we possibly can make. We're not gonna drop them the way we should, the way we already have a system in place to do so. We're gonna invent something new. We're gonna go to GeoCities and make a new website, and half the population knows what GeoCities is. But something like that. I mean, it doesn't make a whole lot of sense. Either you're really not intelligent and you're doing this ass backwards, or there's a reason you're doing this.
Exactly. And I don't know. I cannot for the life of me understand the logic behind it. Especially in light of, the way that the judicial system works and the way that the criminal justice system works is that, if somebody's convicted and they want to appeal their case, they rely on the record and the docket. It's the Bible. Like, if it's not in the record, it doesn't exist in the appellate court's world, man. So it's like exceptionally important that the record is clear, that the docket is clear. So when they did that and then they didn't include the dates of filings on anything, it's like, how, if Alan were to be convicted, how is the appellate court to make heads or tails of the record? So it's like, it was problematic in a lot of different ways beyond just the true crime world being irritated. It was fundamentally incorrect in the way that it was done for, the system in and of itself, meaning that the appellate process is going to be completely jacked up with the case. So that continues to go on all the way up through when Baldwin and Rosie are removed, up until the last thing that she did prior to the OAs getting filed, which was, Rosie had filed his motion to DQ her being Gull, and to state that, he put a verified statement on the record saying, look, I consider myself still to be, thank you. I still consider myself to be Richard Allen's attorney. And, she then proceeded to tell the clerk, remove those. Those guys aren't the attorneys for these guys anymore, for Richard Allen anymore. Take them off the docket. So that was kind of the last act. And after that, that's when Maggie Smith and Carol Weineke got involved with the case. And there was a third attorney. I think his last name was Taylor, or it may be a she. I don't want to misname her, but I'm pretty sure his or her last name was Taylor. So they filed this first thing, and the first OA was basically, look, you screwed up the docket. The docket's a mess, and you didn't follow the rules. And these are the rules, and you need to fix it. And so that was it. Like, and they were right. I mean, the docket was screwed up. Now, I think that you and I did an episode probably shortly after that OA was filed, that first one.
Yeah.
And I think what had also happened subsequent to that is that Gull had filed her court order. So that might have been a couple episodes later. So the OA comes out, she's got time to respond. I think it was around mid-November, and 17th or 18th of November. And the day of her response was due, or maybe the day before, later in the evening, one of those two, she prepares this order that basically corrects everything, that is addressing the clerk and saying, okay, I need you to fix all of this stuff. And she enumerates it. And so I remember coming on with you and I'm like, well, that basically moots out the OA. They don't need to, she did that so that they don't have to really rule on it, because she fixed it without them having to say, yeah, you screwed up, fix it. So ultimately yesterday, so that kind of leads us to where we're at yesterday. So we get two orders dropped. We get the one that basically denies the writ of mandamus as to the first OA, the one that we just talked about, basically saying in there that it's moot because most of the corrections were made, and that, they did go a little further. They did say, which I find interesting, which we'll talk about when we get to the second one. They did put language in there that procedurally they felt that they skipped a condition precedent, meaning that there was something that they should have filed, namely an interlocutory appeal, before they had gone up to the Supreme Court. So they put that language in there. They were very clear, look, you guys should have filed an interlocutory appeal. This could have been handled at the trial court level. And, had that not happened there, then maybe you come up to us, but you guys skip that thing. And we don't see any reason why substantial injustice, would occur if you didn't just file that down at the trial court level. So, and I found that language to be interesting in light of the fact that we have the second OA. So basically they deny the petition. They state that it looks like the judge has done everything that we would have had her do anyway. And moreover, these are what the rules are. Everybody follow them. And so that was it. So that's it. So then we get the bigger news, which is that the second original action, which is dealing with the huge mess that this case has become procedurally.
Yeah.
Which is obviously when we know that Rick Allen's attorneys have been bounced from the case. Gull's been citing that they were grossly negligent in the representation of him. And, it picked a fight. And the fight was the second OA. These attorneys, after they were, I guess, Baldwin withdrew. And then she thinks that Rosie withdrew, even though Rosie didn't think that he withdrew because he didn't orally and he didn't file the motion. But she considered, hey, you gave me your word, buddy.
Yeah.
You said you were going to file a motion and you didn't do it, but it's on the record that you were gonna do it and you didn't. Well, that's on you. I consider you not to be his lawyer anymore. Which, by the way, doesn't follow any of the procedure in the state of Indiana in terms of withdrawing. Like Rick Allen has to be given notice if his attorneys are going to be withdrawing from the case. It's typically supposed to be in writing. Now, I've talked to many Indiana attorneys and they're like, like we kind of played loose and fast with the rules. Like we know what the rule says, but a lot of times it's not uncommon for us to go in and withdraw without written notice. I'm like, yeah, but in those situations, you typically have your defendant standing right next to you and the judge addresses the defendant. Yeah. So that they know that you're withdrawing from the case. And the judge will say, well, what's your position on this, Mr. or Mrs. Defendant? Do you have a problem with them coming out? None of that happened. Like the thing on the 19th, Rick Allen was never even brought into the courtroom. So that all happened out of his presence. And then so you get to the 31st, when after Baldwin and Rosie went to the clerk of court, filed their pro bono appearances, which then took them out of the appointed counsel purview and put them into counsel of choice, because it's two different analyses in terms of the way the Sixth Amendment applies. The Supreme Court in Wheat has said that, look, if you're appointed a public defender, you're kind of, you don't really get to pick and choose your lawyer. You're not going to have a Sixth Amendment right that's, where we're going to interfere with, the court saying, like, we're either going to remove that lawyer or you're going to get that lawyer. It's like, you unfortunately, you don't have the money to pay for it. So you're going to get who you're going to get. And when we moved to where these guys entered their pro bono appearances and they became his counsel of choice, where he was on the record saying, this is who I want defending me. Yeah. My life is on the line. These are the guys I want. And she said, I'm sorry, Mr. Allen, I can't do it. I just find that your guys have been incompetent, grossly negligent, and I can't allow for them to continue on your case. So that led us up to the second OA, which got filed. And that was basically saying all the things that we just talked about, that Rick Allen's Sixth Amendment right has been violated, that these guys were removed without due process under the law. They were given no notice, no proper notice that a hearing was going to take place. A hearing never did take place. No motion was filed by the state. No motion was filed sua sponte by the judge. Like, there was no semblance of what we call due process, where Rick Allen's given notice and his attorneys are given an opportunity to prepare to defend the motion to DQ. None of that ever happened. So those are the issues that are at play. And the thing that kind of gets lost in the shuffle is, in the meantime, there was a trial date set for this thing. And that was January 8th, fast approaching. If you think about it now, we're like a month out. What would have been the beginning of the trial.
Less than,
And defense counsel was on the record saying they were ready to go. They were going to be filing a speedy trial demand, which they would have kept that trial date. They were going to be ready to go, which I think terrified the judge. Yeah. I think that the thought of everything that had to be done in that short a period of time put her in a position where she's like, oh my God, I have to figure something out. And she ended up using the leaks that occurred, And, the other few things that she put in there about them filing a notice of preserving Allen's right to file civil suit against Westville Prison. And, there were a couple other things. None of them rose to the level that these guys should be removed from the case. They were all collateral type issues. The leak, had it gotten out to the public en masse, maybe then we're having a conversation. Well, did that taint the jury pool?
Yeah.
And then we're looking at like, okay, well, Baldwin didn't do it intentionally, but, was he sloppy in that, like, he didn't have his door locked every second of every day if he's not in there to the conference room, which to me is unreasonable. It's just not realistic in terms of a law practice. Because these aren't classified government documents that you have to, have to have some kind of classification in order to view them. They're crime scene photos, and it's discovery from a case that's going to be a public trial. So
yeah, and they're not working at a Regis, where it's
right,
like
exactly
a shared office space or something of that nature.
Exactly. So ultimately, we get to the point where this order comes down. We're all kind of hoping that an opinion would come out. And ultimately, we find out that they're going to have oral arguments on January 18th at 11 a.m. at the Indiana Supreme Court, where they're going to argue it out. They get an hour total, half hour each side. They can break it up. So, I know that if you're following the case heavily, and Kara is not going to be arguing it. Her co-author in the petition is Mark Lehman, is going to be arguing in front of the Supreme Court. And that's because Kara's got another argument in front of the Supreme Court the following week. So, she wants to be prepared for that. So it's going to be interesting, man.
Sick of the ads?
We are too.
Start listening with no commercials now and get access to all of our episodes in advance of everyone else.
Become a True Crime Today Premium Plus subscriber on Apple Podcasts.
Search True Crime Today Premium Plus on Apple Podcasts or go to our podcast page and sign up now.
True Crime Today Premium Plus.
Sign up now.